Yep.
All right, and I'm required to remind you at each hearing that you do have the right to be represented by an attorney, including an attorney at public expense if you qualify and request. All right, well, we're here for a docket call that I had scheduled because Mr. McLeod had requested a jury trial, and I wanted to touch base and have you both submit proposed jury instructions, which I did receive. And so what I want to do is I'm going to ask the bailiffs to deliver to you two packets. One is the ones that begin with 2.1. Those are the preliminary, it's for defense, preliminary jury instructions, and then the 3.1, or the ones that start 3 point. Those are the final jury instructions that I would propose to give, so those will be for your review. Count 1, the defendant is charged with contravention, resisting, obstructing. That's
This is one of those courtroom moments that feels more like theater than law. Meet Trevor McLeod, a self-proclaimed sovereign citizen who denies the authority of the very court he's in. From the start, he returns legal mail stamped. Offered to contract denied, clinging to the illusion that justice is a business deal he can opt out of. But today, Judge Fleer isn't entertaining fantasy, he's enforcing reality.
A bit of a strange statute, and there's no model jury instruction for that charge precisely. The prosecutor based it on 13.2, which I think is correct, although I did amend the prosecutor's requested charge to add some language from 13.1 that is also a correct statement of the law, particularly the statement that the defendant must have actually resisted by what he said or did, but physical violence is not necessary. And then also, because Mr. McLeod, you've raised a lot of legal challenges in this case that I have denied. Typically, challenges on the law are for the court to decide and not the jury. And you wouldn't be able to present those arguments to the jury. However, because you're charged with resisting and obstructing the concentration officer, the lawfulness of the officer's actions is indeed an element of the offense. So I am required by law to instruct the jury on the framework that they need to decide that. So I've included some language for that the prosecutor did not request. Obstruct includes the use or threatened use of physical interference or force, or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. The defendant is a member of a Native American tribe that is a party to a federal court consent decree that binds the state of Michigan and its law enforcement officers. Under the terms of that consent decree, tribal members operating boats or other vessels who are engaged in the exercise of a treaty-related hunting, trapping, fishing, or gathering activity shall not be subject to state vessel registration requirements, provided that the tribal member satisfies tribal license requirements for the activity in question, is in compliance with the applicable tribal hunting, trapping, or fishing season limitations and tribal law adopted pursuant to, and possesses evidence of being currently engaged in hunting, trapping, fishing, or gathering, such as fish, game, or common items related to hunting, trapping, fishing, or gathering, such as fishing rods, tip-ups, firearms, traps, or nets. Fourth, that the defendant's actions were intended by the defendant, that is not accidental. So in instructing the jury on the framework for which they should consider whether the officer's actions were I'm including in that instruction black letter law on reasonable suspicion and probable cause for a stop and rest, and I've included the direct quote from the consent decree that I believe is the provision that you've been arguing, Mr. McLeod. Mr. Juliet, the people have...
You can feel the judge's precision in every word, calm, measured, and authoritative. He doesn't mock or argue, he educates. Each jury instruction serves as a reminder of how structured and deliberate real justice is. Meanwhile, McLeod clings to his fantasy of contracts and sovereignty. The irony? By representing himself, he's bound by the very system he insists isn't real.
And that's a lesser offense. And I'll let you think on that. We're going to come back for another docket call in July. If you request a lesser included, we'll do that. A couple other things for jury selection with Mr. McLeod representing himself. The law does allow the court to conduct a voir dire, and I'm going to go ahead and do that. So I'm signing an order today that on my own motion, I will examine the prospective jurors during jury selection and not allow direct questioning from either the prosecution or the defense.
I object to that.
Noted and overruled. But I'm giving both sides, as required by the court rules, an opportunity to submit written questions So you have to submit written questions to me not later than Tuesday, July 2nd, so I can review them. And we're going to come back for a docket call on July 9th at 9:30 a.m. I will not ask questions that I determine are improper, irrelevant, or unnecessary.
I'm sorry, you have a jury of my Native Americans, my peers?
No, sir. It's a jury selected at random from folks in the county. All right, and also, Mr. McLeod, you've waived your right to counsel, and we've gone through the waiver process, and I believe that you have knowingly, voluntarily, and understandingly waived the right to counsel with your eyes open as to the risks of self-representation, that you're choosing to exercise your constitutional right for self-representation. Of course, doesn't allow you to become disruptive to the court processes. You've not been doing that of late, but there was some history early on of that. So under Supreme Court precedent, Florida v. California in 1975, this court may, even over objection, appoint what's called standby or advisory counsel to aid you if and when you ask for help, or to be available to represent you in the event that the termination of your self-representation is necessary. So therefore, on my own motion, I'm appointing the Sheboygan Office of Assigned Counsel, not to act as your attorney, Mr. McLeod, but to act as what's called a standby or advisory counsel. So they'll be present at the hearing in July and at the trial. That they won't participate. They'll be there to give you advice if you have any. If you don't have any, they won't give it. And then if, for example, you became disruptive during the trial to the extent that even despite warnings, you persisted and had to be removed, then the attorney would jump in and finish the trial on your behalf. But as long as you're not disruptive, that's not going to be an issue. But they're there just as advisory counsel for you.
I object. I want to represent myself.
And I'm going to let you represent yourself, but I am going to appoint a standby or advisory counsel just to assist you if you deem necessary. And then I did notice as I reviewed the witness and exhibit lists that were submitted by both parties, Mr. McLeod, you had listed both magistrates in the district court.
This is what true control looks like in a courtroom. The judge sets firm boundaries with quiet authority, granting Loud the right to represent himself but assigning standby counsel as insurance. It's a strategic move that keeps the trial on track no matter what chaos unfolds. A reminder that self-representation isn't freedom from the system, it's full responsibility within it.
Probate court judge, the elected prosecutor, and a retired circuit judge. Can you tell me what
It's all pertinent to my situation.
In what respect? What testimony do you think that they'd be offering would be relevant at the trial?
I don't need to say all that right now.
Yeah, you got to tell me that it's relevant, because I don't see how that's possibly relevant.
Well, the magistrate and the prosecuting attorney went ahead and prosecuted this case without having a warrant on file. The judges all looked through this file, didn't have a warrant on file, still pursued it. So I mean, it's kind of like your job, isn't it, to make sure all the paperwork's in order?
Sure, but that's not relevant to what the jury has to do. What the jury has to decide is whether the officer's actions on that day were lawful, and whether you were resisting him and or operating a motorboat while intoxicated.
Not guilty if he is guilty of a charge.
One more outburst, you'll have to leave. So the judge's testimony, magistrates and prosecutors, not admissible or relevant. So I'm going to strike from your witness list Magistrate Ellenboss, Magistrate Libby, retired Judge Spartan, Judge Vizina, Prosecutor Goodrich, and retired Judge Pavlich. So you may not call those folks as witnesses. Both have until July 2nd to file witness and exhibit lists, to file requested questions that I would ask the jury during jury selection to achieve a fair and impartial jury.
We're not going to get a fair and impartial jury because they're not going to be Native Americans. It's the whole situation.
Well, that doesn't, if somebody's African American, we don't seat an entirely African American jury. If somebody's Asian American, we don't seat an entirely Asian American jury.
It's not a jury, not yours.
It's not. Well, sure.
The argument that I'm fighting is based on the treaty rights. That's the whole thing about it.
Yeah, in fact, it would violate the Constitution if I tried to seat a jury of only Native Americans and excluded people based on their race. So I will decline your invitation to engage in racial discrimination. So you have until July 2nd to submit written questions, and we'll come back for a hearing on July 9th at 9:30 so I can tell you which of those questions I'm asking or not asking. I'm granting Mr. McLeod's request to add the definition of operating, and we'll give him until the 9th to decide if he wants the lesser included or impaired.
Then comes the turning point. McLeod demands an alternative jury. claiming tribal law gives him that right. The judge fires back, calm but firm. That would be racial discrimination. In that instant, the sovereign fantasy crashes into constitutional reality. This isn't bias, it's balance. The law protects fairness, not favoritism, and justice doesn't bend to personal definitions of sovereignty.
And the clerk's office would provide notice to standby counsel as well. Notice has been provided. We confirmed with your office that you were the one. All right, Mr. McLeod does not appear to be present in the courtroom. Is he in the hallway? He's not in Zoom either. He's not appeared. Have you had any contact with Mr. Trevor McLeod?
To my knowledge, the entire.
Well, Mr. McLeod has been representing himself. I did appoint standby counsel at the last hearing. Standby counsel is present. But since the last hearing, Mr. McLeod has refused to accept mail from the court. We sent a mailing to him with copies of the orders that I entered at the last. It was sent back to us with a red marker stating return to sender and offer to contract is denied. So sadly, Mr. McLeod seems to be retreating back into nonsensical sovereign citizen defenses. And he filed a document, or there's a document purported to have been signed by him, titled Letter Rogatory for Relief, that is legal nonsense that somehow accuses the court of somehow generating funds from the case using defendant as some security mechanism, which makes no sense at all. This is not the first problems we've had with Mr. McLeod, and now he's choosing to refuse service from the court and refusing to attend here today. We have a jury trial scheduled August 8th and 9th. Mr. Juliet, any requests from the people?
This is his first failure to appear, to my knowledge, but I wasn't aware that he was deliberately refusing correspondence from the court. So based on that, I would ask for a bench warrant. All right, Mr. Wergo, any input from standby counsel?
Yes,
you don't represent him, but you're here to stand by and give him. You're here to give him advice if he is here, if he wants advice, and to stand by to represent him if he's not able to represent himself. And him not being absent, I guess, if you want to say anything on his behalf, I'll let you.
Yes, Your Honor. Being that it is his first non-appearance, and it appears that he is maybe under the impression that there are some legal mechanisms at play that aren't, I would ask that instead of a bench warrant, the court issue a show cause and allow our office an opportunity.
Well, he's not only not here today, he's refusing to accept anything that we're sending him. He's repeatedly demonstrated contempt for this court's authority and process. I'll issue a bench warrant for his failing to appear with no bond. Do we leave the trial date on for now, Mr. Juliet?
Yes.
Okay. Normally, I would cancel the trial date. I'm going to give Mr. McLeod the courtesy of not canceling that trial date because I don't want him to be sitting in jail for a super long time on this case. But I guess my staff will monitor that. If he's not in custody soon, we'll be canceling that date and using it for other.
This is the crash landing. McLeod stops pretending. He ignores the court, refuses mail, and shuts himself off from reality. The judge's patience finally breaks, issuing a no-bond bench warrant. What began as arrogance ends in isolation. Because in the real world, law isn't a contract, it's accountability. When you don't show up, the law will. Cases like this prove the courtroom isn't a stage for ideology, it's a test of respect. When belief collides with justice, the gavel always wins.